Good afternoon, everybody. I'm opening up right now. One of our speakers is going to be, hang on a sec, is going to be, oh, here we go. Found him. It's calling in. Let me allow him in. Okay. Matt Surge, can you, let me unmute you. Actually, it looks like it's, sorry, I have a phone number, which I think is our one of our presenters dialing in, and I don't seem to have the option to, and your mic should be enabled. Can you hear us? Okay. I'm going to have to work with Matt on how to get him onto this meeting.
Hi. In the interest of time, do you want me to just start fielding? And
that would be great.
you will not, I mean, it's obviously,
yep.
It's better to have both of us, but
right.
Half a loaf is better than none, right?
Yeah, I think so. So we have some questions which are coming in now. The previous session, we answered them as far as the one that was asked at 1:43. The one from 1:59 p.m. was a reference also to the previous discussion, as was the bill text at 2:05. So I think we'll need to direct those to Steve Whitley.
Okay.
And so that therefore the newest, the oldest one that's just been coming in during this session is from 2:12. So
okay.
if you want to start with that.
I had a couple from my prior. Do you want me to address those at all, or not worry about them?
Yeah, please do if you wish. Yeah, that would be fine.
Sure. One for Audrey. Greetings, Audrey. Glad you joined us. Yes, I believe it's still the case that equitable waivers are not allowed for use type violations. They have only dimensional. That's both the statute and the Schroeder case. I know of nothing that changes that. Andrew, you asked for lawful methods to keep order. A strong chair, a good loud voice, and not be afraid to say, I'm going to take a recess if this continues. Those usually will work. It is also important to make sure the board members do not contribute by doing the natural gingham dog and the calico cat routine of, escalating up. Let questions come to and through the chair would be one way of handling it. But whole seminars are given on how to deal with a toxic environment. So it's beyond our ken for today, but those are a couple things. Peg, you asked how to train new board members. Well, get them to things like this. Have them look at the written materials from things like this. Have them read the relevant statutes that are in the Bible. The white version now is the 2324 edition of New Hampshire Planning and Land Use Regulations. And the best way of training new members is to have them serve as alternates, and that you're watching others do it, not lobbing in your 2 cents when you've just joined the team, but being a good student means showing up.
So Chris,
yes,
I think Matt is now audible. So Matt, can you just let us know that you're there?
Hi, I'm here. Can you hear me?
Excellent.
Yes.
Okay, good.
Hallelujah.
I can hear you too.
All right.
All right, we're all in.
Thank you. Yes, we're here. I'm here.
Okay. I was going to say,
sorry.
There are some new questions that are coming in, but there were also some questions back at the very first session, which we never got to. And do you all wish to tackle any of those?
Whatever you wish,
Okay.
Ken, we're here for you.
Whatever.
Okay.
Yep. Whatever you're.
I'm gonna go-
works for us.
Sounds good. I'm going to go way back to almost the beginning. The first question I think was covered in Chris's subsequent presentation, but the next one that we got was from 906. Regarding mechanisms for relief, is it correct that each such is a type of appeal, i.e. an appeal for a variance, an appeal for a special exception, an appeal for administrative decision? Does that fit any of your?
Yeah, I thank you. I know for me, I have a little bit of picadillo with that terminology because I see there's applications and then there's appeals.
Right.
I know the statute is a little puzzling the way it uses the word appeal, but I say when someone asks for a variance, special exception, equitable waiver, they're applying for relief. If you're challenging a decision of an administrative officer or a decision of the planning board interpreting zoning, that's an appeal. And to me, an appeal has certain there are certain rights that follow that, which are different than an application. So I just do not see them as interchangeable in terms of their terminology.
I agree.
I don't know if
No,
yeah.
I do agree wholeheartedly with you, Matt. In fact, I have become counsel to towns where they have it set up as an appeal for a variance or an appeal for special exception. And I try really hard to do just as you said. The statute doesn't use the term appeal when it's under 674-33, the other two and 3 for the special exceptions and for the variances. We have an appeal of administrative decision. Let's follow the statutory language.
Mm-hmm.
Great. Okay. I'm going to move on. This one might be a specific question, so just let me know if you think it should be answered. 2 of 3 select board members appeared at a ZBA hearing with counsel to speak for them about why the applicant was denied by the select board. The applicant asked for a continuance so that they could also have counsel. Does the ZBA have a right to require the select board to notify the ZBA before a hearing that they are coming and bringing counsel?
Gee, that sounds like a very specific hypothetical.
Just a little, yeah.
You want me to go out on the limb?
Yeah. Why don't you take this one, Chris?
I don't think there is a requirement that for an appeal of administrative decision, the underlying officer give notice that, hi, we're coming. Because that's implied in the appeal. The code enforcement officer, I think, should be there because they're there to defend their decision. The appealing party has the burden, but there may well be questions from the board to the underlying decision maker. The dicier question would be to avoid a violation of 91A. I would strongly suggest that the select board notice that they're going to be at the ZBA. It's not a selectmen's meeting, but it gives notice to the world that, hi, they're going to be there. Because especially in small towns, we all know whose cars are where at town hall. And, oh, why are Joe and Sally's cars there? It's not a selectmen's meeting. They're having an illegal meeting. You avoid all that kerfuffle by simply posting, hi, the selectmen are going to attend the ZBA or the planning board meeting to observe or to defend their decision or whatever. It's not official action of the select board taking action within their jurisdiction. It's them notifying the world so as nobody gets upset. Just kind of a prophylactic. That's my 2 cents.
Okay, thanks. Matt, it looks like I might have muted you. Do you recall how you became unmuted the last time? I'm not quite sure how to unmute you.
And I swear I didn't
There we
do
go.
it to
It's
keep you from
back.
saying something.
Okay, it's back.
There you
I
go.
think he's
How's
done it.
that?
Sounds good. Okay.
How's that?
You're here. Okay.
I
Next
remember.
question.
Do you have any
I was just
comments
gonna
on
add
what
that-
I said, Matt?
Yeah, I agree with Chris, and actually, my mind immediately went to the 2 out of 3 selectmen at another meeting that just to be safe, and I think I said this in my presentation about, going crazy with notice and the process is cheap. Just throw the notice out there; they're going to be there. Just avoid the kerfuffle, as Chris said.
Okay. This goes back to the first session regarding the receipt of application. What about an application that is deemed incomplete? Is it correct that the clock starts on receipt of a complete application?
Yes, that would be my position. It has to be complete, meaning the fees paid, the lines are filled out, and it is, it is a application that is able to go before the board for a review, meaningful review.
Okay.
And more importantly, I think it's the board's decision that it's complete is the real trigger of the start clock. But if you're viewing that it is not complete, you have to be very specific on what is missing so that the applicant can come in and provide those 2 or 3 missing items.
Yeah, well, it's interesting. If we can we go off of this a little bit?
You bet.
Sure.
Yeah, because I know, Chris, we were talking during our session about, the 45-day and 90-day clocks now for having a first hearing and then making a decision. It uses the word, receipt of application.
Yes.
So, I see that as when that thing is stamped received by the town in the land use office, if that application is fully, quote, complete, then that clock has started running. Unlike a planning board where the clock starts to run when they actually accept the application as complete at a meeting. What do you think of that?
I agree with you, and thank you for the reminder. We have 2 times. One is you have to hold the first meeting within the 45 days, and I think that's what you're talking about. And that's a non-board action. That's a staff action. Now, hopefully the staff goes through the application before they stamp it. So that you can, I know several towns that I'm on the Forces of Darkness side, filing applications. And I still am an old curmudgeon and walk the things through to make sure that they are complete, that I know if the staffer is saying, whoop, you're missing something, Chris, get this to us so I can get it immediately. And we don't have a delay with the mails.
Yeah. Okay.
Okay.
Continuing through the first session, is there a financial difference between tabling a case for more info versus denying without prejudice? In the latter case, does the applicant incur another cost for filing a new application?
Well, Chris, why don't you start that one off? Go on.
I guess the answer is it depends. I would say that if you are denying without prejudice for the specific things, that is technically the denial. So at the very least, they need new notices.
Agreed.
They have to pay for the new notice fee. I haven't had as many of those since the statute really changed to with 1661 in January of 23 to have a book of experiences to say more folks do X than Y. But I would think that if it's a denial, it's a new application coming back. If it's tabling, and I would prefer the use of the phrase, we're continuing to X date, and X date might be 6 months out, is the only way to avoid the new notices and filing fee.
Yeah, I'm of the same mind. I think if you're denying, and the same with Chris, I haven't had much experience yet with the denial without prejudice. I think that's 1 or 2 boards do it. But at that point, that is a denial. It just means that, as we talked about in the first session, they can refile for the same thing. They're not barred by Fisher v. Dover from reapplying, but they got to at least pay the fee for the notice again to start it up. But yeah, the tabling, I know at town meetings we see people table articles, and that's one thing. But here, I prefer continue as well to a date certain, so at least we have the thread of the notice continuing, and we can just reconvene, and if it continues again for whatever reason, we just keep continuing it. But yeah, I'm of the same mind.
Okay. Another question. What about people without standing testifying at a hearing?
Yeah. So
we have one of those, don't we, Matt?
Oh, sure. Well, no, we talked about this a little bit in the first session, and that is about allowing non-abutters or those, quote, without standing to speak at a proceeding. And, I think it could be in your rules of procedure, but I mean, I think, again, I've seen it done where the chair often will just poll the board and straw poll to see if they will allow someone to make some, brief comments, because the chair again controls the meeting and doesn't have to let it get off the rails with someone, but they can let someone speak if, they're not necessarily again, someone with, quote, standing. But I think it is discretionary. I don't think they can't force themselves to be allowed to be heard. But right. I generally say, what's the harm? Let the person speak. You can, again, control the time limit. You don't need to let them go on for an hour. But why not just be a little bit more, relaxed with that approach? I think it saves some headaches later when someone's going to try to claim a due process issue or something like that. Just let them speak.
Right. I'm of the same mind. It's a public hearing. They may be members of the public. There is a lovely phrase that the judges give all of us when we are putting forward something that may or may not be really on point. It's like, Mr. Bolt, I will let it in and give it the weight it deserves. That's a wonderful, polite way of saying it's coming in, but thanks for playing. There is a difference, however, between a person having standing to testify, which is fairly broad, and being an aggrieved party with standing to file a motion, request for rehearing or a lawsuit. It's a very different standard. So there's a lot of folks that can speak, but not a lot of folks that can have standing for a request for rehearing or to be able to then file a lawsuit.
Okay.
Yeah, I think that's an important point. I really like to think of standing more in the context of the appeal rehearing type process and the rights to file those, rather than standing to speak. I guess that's kind of where I come down.
Yeah.
Okay. Next one. NHRSA 673:16 allows the ZBA to hire consultants.
Yep.
When is such information brought forward? As part of a hearing or during deliberations?
Ooh, let me jump on that one. During the hearing.
Go ahead.
It's got to be during the hearing because it's public information. Anybody that is involved in the lawsuit may well want to counter whatever the town's expert reviewer has done. Definitely the applicant will. I've known several cases where the abutters, if the town expert comes in and says it's going to be dark tonight, they're going to contest the decision. So, it's got to be during the public session, in my opinion.
I completely agree. In fact, I'll add a little more to that, just because I had experience with this once. If you're doing a peer review study, for example, of maybe an applicant's study, that too, any review of a review, it all comes in during the public session. Don't close your hearing and then receive something and then take a look at it in your deliberation. I saw that once, and that is not right.
Yeah, that's an automatic ticket back. Think of it.
Yeah.
Again, you're a quasi-judicial body. You're acting like a court. The evidence comes in front of the court. Then the court makes its decision after the hearing's over. The public hearing part of it is over. Public meeting, though, is still going on. That's the distinction line.
Okay. This next one is kind of in response to the actual, the specific presentations today, asking, when you cite cases, can you please identify if the decision was issued by an actual court versus the HAB, the Housing Appeals Board?
Well, the members of the HAB may take umbrage at that, but neither of us are. So I try to distinguish, I will say the HAB ruled or the Supreme Court ruled to make it a distinction that way.
Yeah, I don't recall. I know for us, I think we just cited cases, but from courts. But nevertheless, it's a good point. And normally we would say to have if we're referring to a housing board decision.
Okay. Okay. Next one. This person says, we have a select board member as a ZBA member. Is there enforcement obligation on a case enough to be a cause for recusal?
I trust is means if. I think if the enforcement, keep in mind, the decision to enforce or not enforce something is expressly outside of the jurisdiction of the ZBA by statute. So if the member who is a select board member that is also a ZBA member, they should recuse themselves if the ZBA is considering an action taken by the select board. It's because you're in essence a member of both bodies. Whoever is, whichever body acted first, you don't sit on the second body. And that can be whether you're a select board member, a planning board member on the ZBA, Concom, whomever. Because the ZBA is a quasi-judicial body. You're supposed to be like a court. A court, the judge is not also the prosecutor. It's not also the bailiff. It's the judge is the judge. You don't take on multiple hats.
Yeah, I was gonna just echo that I know I've seen it often in the planning board, zoning board issue, where you have someone doing double duty. And as Krista said, you don't sit on appeal of your own decision. And that's essentially what a member is doing if he or she is reviewing the actions of the other body that he or she sits on. So it's just, to me, that's a clear line.
Okay. Next question. Doesn't the 2-year lifespan of a variance impose an automatic timeline on conditions precedent?
That's a great question. And that kind of dawned on me earlier when Steve and I were talking about the issues with that. And I know we didn't discuss the 2-year period, but I know Stephen had mentioned the conditions preceding. The statute says what it says, and that the variance is good for 2 years. I suppose the question is, as we know, a decision is not final until conditions preceding have been satisfied. So I think there's probably a decent argument that 2-year period runs when a decision is a final decision, meaning the conditions preceding have been satisfied. What do you think, Chris?
I agree with that completely, because
I think that's what the judge
you might not get the conditions preceding met, and therefore you don't have a final variance to go build on. So yeah. I agree with you, Matt, that it's when we have conditions precedent, sometimes it's good to think about, and this is usually the planning board world more than the ZBA world will have conditions precedent. We'll have you got to get the shoreline permit from DES. You got to get the septic system permit from DES before you can go build the house in the setback. Those are conditions precedent in the ZBA world. And, when I am on the private side of life, I frequently, especially in a contested matter, I'll try to have the golden ticket from DES in hand when I come to DES, come to the ZBA. So there's not a condition precedent. I've gotten what you would want me to get already. But those are conditions precedent, and I think technically you don't have a final decision until you have those. Now, an interesting corollary Matt, I'd like your thoughts on this. Could you set a condition, a timing condition on your conditions precedent? You need to get your DES and shoreline permits within the next 6 months.
Yeah,
I'm not
I think you could, but I think you'd have to have some ability for that to be extended, as we've seen with other telecommunications towers, for example, come to mind.
Right.
Because you're relying upon third parties to cooperate with our timeline.
Right, and DES is horribly short-staffed right now, and
yeah,
I wouldn't suggest that as a course, a normal course, but if it is something that has
I think if it's something within sort of their sphere of control, you know what I mean?
Or it's something that's an unusual case, like the Garrison v. Henniker case was unusual, that the ZBA put conditions that were owner specific, so that it wasn't just running with the land.
Right.
There had to be, that was because of the dog and pony show of the safety issues that the applicant had put on. I think that made sense. I'm trying to think, could there be a timing condition on getting conditions precedent done that would make sense for a ZBA decision? And definitely there are in planning board world. You need, we need the engineers to get the final set of plans to our engineer within the next 45 days and our engineer to review them within the following 30 days, something like that. Just so there's an impetus to get the damn thing done. I don't know that there's a corollary in the ZBA world.
Yeah, I mean, I think you could, but again, you'd have to be reasonable and flexible with it, depending on the condition you're kind of. And just to round this out, I happen to have my computer open, and I went to the statute 674-33, and it does say the 2 years from the date of final approval. So I think that further supports what we're saying about the meeting the conditions preceding first.
Right.
Okay.
Just wanted to add that.
Good.
There was a subsequent question by another attendee, which you may have already just answered. In case of conditions precedent, is it correct that the approval is a conditional approval? And therefore, once the precedent condition is satisfied, the board needs to issue a final approval?
And the answer there is, it depends. If the conditions precedent are viewed as administrative, getting the DES permit, revising the plan to have a note change or something like that, I'm not sure that it has to come back to the board, although in complex cases, I have expressly called it out in the findings of fact so that the board decides one way or another, although this was planning board world, what had to come back to the board for a board decision versus what could the chair and the engineer sign off on. ZBA world, I'm not sure you're going to have too many things that have to come back to you.
Yeah, I'm kind of thinking the same thing. I think that definitely is a big contrast there with two boards. And, unlike the planning board, we have nothing really on the zoning board and how that works. But I agree with Chris. I mean, for lack of any direction, I follow that same guidepost. And that is, if it's purely administrative, there's no need to do anything more than just, make sure the condition's satisfied and final approval is signed. But if it's going to be something that's contentious or it's going to generate a lot of public interest, might not hurt to have another hearing real quick just to review it and make sure all the I's are dotted and T's are crossed.
And I have had a case where it was planning board, but the conditions precedent and the findings expressly said chair and engineer. Chair gets the engineer's letter, brings it back at a public meeting of the planning board just to say, hi guys, we got this. Everybody okay? And it's like, yeah, everybody's okay.
Yeah.
But I think that might have been overkill, not necessary, but such is the nature. Ken, we have a lot of new questions.
Yeah, we're getting really close to the end of the old ones, so
Okay.
we might be able to get
Just
through them
checking.
pretty. Yeah, we got just two more.
Okay.
So we'll just get right to it. Next one. For a variance, all 5 conditions must be met for approval. If it doesn't, when doing the denial, does one have to go through all categories as part of the record, or can one just state the categories where it fails?
Ooh. Okay. Well, I'll go first, Chris, if you want.
Perfect.
I encourage boards to rule when they vote. And again, my position, I think I said this in the first session, is I'm not a big believer in voting on each criteria. I like to see everybody discuss everything, make sure it's clear in the minutes, but then vote up or down on the overall variance with the reasons. But when they're doing that, I encourage them to address all 5 criteria. And I say that because, and this just happened to me actually with the Housing Board of Appeals, if one is not addressed and it's not part of the denial, Housing Board of Appeals interprets that as being met, that condition was satisfied because we didn't deny on that condition. Now, I'm not sure I agree with that, but that's how they look at it. So I tend to like to see all 5 criteria, speaking of variances, addressed, and if it's denied, explaining why they failed to meet all of them. Granted, you only need to fail one to not get your variance, but again, I worry about on appeal judges and board members who are interpreting a silence as some suggestion that the element was satisfied because it wasn't included in the denial. That's just my take.
Yeah, I tend to agree with you. It is one where I don't like the vote on each criteria because you may get a scattering of votes.
Yeah.
But remember, the statute says continue to follow the practice that you're following. And if you're going to change from a voting on each single one to voting as a block, do they satisfy the criteria or not? You have to give 60 days notice of that change, and anything that's in the pipeline is using the old version until that application that's the first after the 60 days. I think it's cleaner to vote as a block after, as Matt clearly says, you discuss every criteria. And remember, my phrase is remember because statements. They do or do not meet this criteria because, and state some evidence that you have heard. Tie things together. Those are your findings that are now required, and that supports your decision in front of the Housing Appeals Board or in front of the court. My question for you, Matt, was do you think boards could get away with what the court gets away with in saying, in essence, we find this one is not met, and accordingly, we don't need to address the other issues raised by the applicant? That tag that's at the end of so many cases that says, the appealing party wins on this one, and therefore we don't have to address all the others, or they lose on this one, and therefore we don't have to address all the others. Would that work, do you think, in the ZBA world?
I think it could. I think the key to me is that that's showing an intent on the part of the board that its silence should not be interpreted as an approval of the condition that was satisfied.
Right.
They simply didn't address it. I know, just to spin off of that, and I think this is something that a number of boards have probably experienced, sometimes you'll have multiple variances at the same time before you.
Yeah.
And I've had situations, and you probably have too, Chris, where they review one variance, but let's say it's denied for whatever reasons, but they address everything and they just deny it. And then they don't address the second variance because why should we? We just denied the first one. So
right.
The second one's moved now. I've had that happen a couple times. I did have the Housing Appeals Board, because I was challenged, of course, and said they can't do that. They have to rule on everything. It's before them. They can't ignore it. And I did have the Housing Appeals Board in its first iteration with Greg Michael actually say that was okay, that they were allowed to do that because it was moot and they didn't have to address it. Subsequently, I had another Housing Board, different makeup, which kind of now said, well, you don't have to, but we really don't think you should do that again. Next time, address it. So, That's a separate issue. But yeah, I think, Chris, for the other elements, I think they could. And of course, you face the remand if the board finds that the reasons you stated, if it doesn't fly, then they could send it back. But yeah, I think they could do that. And I think at least that would get around the problem of being, the court or board ruling that these were met or satisfied given the silence. I think that would get around that problem.
Yeah, my only hesitancy, since I threw it out there, I started to second guess myself because of 1661's amendment of 676.3 on what has to be in the decision, the findings. I'm wondering if we aren't, in the case of disapproval, any application, that's the planning board, issuance of a decision, local land use board shall issue a final written decision with either approves or denies, makes a copy, failure of the board. The decision shall include specific written findings of fact that support the decision. Okay, it didn't say all reasons. I mean, it has to have specific written findings of fact to support the decision. Accordingly, I think you could get by with, you miss out on the unnecessary hardship. We don't need to address the others. Therefore you lose, and you have specific findings that might count. As an applicant, I would want to know everything that I didn't get, so that I know what to address in my motion for rehearing. And so there's a tension rather of what is your Carbono v. Rye obligation to assist, when is that met, versus when are you acting like a court in your quasi-judicial capacity, and the court does it all the time. We're quasi,
sometimes too much.
Yeah, judicial. I don't know. We may be dancing on the head of the pin right now, but it's an interesting concept, and I'm sorry I diverted us.
That's okay. Thank you. Last question of the old questions, and then we can get to the ones that people are putting in the comments. This question: what is included in the complete certified record, and can the contents be appealed?
Well, interesting. A certified record to me is every scrap of paper that the board accepted as part of the case, and that's everything from the application to the sometimes a photocopy of a check that's sent in for the fee, to the authorization form, the minutes, the decisions, photographs, any reports submitted, letters from abutters, emails, you name it. I mean, it's all part of the record.
It goes to the board. It goes to the board, right?
It goes to the board. Yeah, all part of anything that the board had, and it was part of its case. Literally, it was accepted. And just as a side note, what I usually do, I learned this way back, and maybe Chris does this too. I also add a copy, if it's a specific property, I'll often just add a copy of the tax card and the tax map, just so it's for reference, and I never get any pushback on that. If it's not part of the record, just for, again, reference point only. As far as appeal, I mean, often I've seen people challenge a record and say it's incomplete, or you're missing XYZ, and hey, that's fine. We all make mistakes, and staff can only do so much. And when you're dealing with a case with 1,000 pages, I know Chris knows about that. You might miss a page or 10. So we usually work that out behind the scenes. I think what I see more often is complaints about minutes not being accurate in the record, and there's a request to either submit recordings or the videos from YouTube or whatnot if they've been recorded, and that kind of thing. So I hope I answered the question. I think that's my position on that.
I agree, and with respect to videos or YouTube, the official minutes are the official minutes. That's it. There is a Superior Court rule I haven't had this situation in the Housing Appeals Board, but I have in the Superior Court where somebody wanted to come in. Here's the DVD of the meeting, and you need to watch this. And it was Judge O'Neill. And Judge O'Neill's eyebrows knit together and looked at it, and he was going, "Have you prepared a transcript?" "No, I'm giving you the disc." Superior Court rule, and I forget what the number is, requires you to give me a transcript. I am going to pass on the opportunity to watch your movie. And it's like, there you have it. So it's one where I try to avoid the videos, both sides of the aisle, just because usually they're so poor, and people are talking over each other, and it just doesn't advance the ball. The minutes and the documents are usually good enough for both sides. But like you say, if there's been a page or a document missed, opposing counsel will raise it. "Hey, Chris, you blew it. This one's not in." I'll confirm it's not in. Go, "You're absolutely right, Joe. Let's file a supplement to the record. Not a problem." I don't know of anybody that would say, no.
No, right, exactly. And I don't know about you, Chris, but very rarely there's big contentious cases, you'll see applicants, usually represented by an attorney, show up with someone who's taking a transcript or even videoing the proceeding. Right. I've had that happen once or twice, and and that's okay. I mean, as long as we get the transcript and verify it, everything is matches and things. Usually, I don't object to something like that. But again, I kind of laugh. It's like, that's their dime. They want to spend money on that.
Exactly. Now, I have objected to the Dragon Speak or AI Auto or whatever it is that took minutes on somebody's phone. And my best case was when somebody did that from the beginning of the meeting. The meeting always starts with the Pledge of Allegiance, and it was so bad you couldn't say that what they were talking was the Pledge of Allegiance. So it's like, strike this one, and the judge did.
Yeah.
So,
for you.
What else we got, Ken?
Okay, I think we're getting into this session now. New stuff. First one I have from that: how do you handle an abutter at a ZBA meeting who claims not to have been notified?
Check the abutter list. Check the green cards.
Yeah, I mean, if they claim they weren't notified, I mean, they can say that, and then we check our cards and lists, make sure it was mailed. We have an obligation to mail it. We don't have an obligation to ensure that it was signed for.
Right.
And I don't know about Chris, but I always encourage certified and first-class copies to go out anyway, just so first-class copy doesn't come back. It's implied that it made it to the mailbox.
Right. I will do that I may not advise that on every case. I'm not sure you need to do it on every deck case. The major abutter is going to be there. A highly contentious one. The ones for regional impact, potential regional impact under 36, you send those out just to make sure, certified and regular, that'd be great. It's not an obligation under the statute, however. All you have to do is verified mail, which technically means certified or registered that they don't have to sign for. I always want the green card. I pay the extra $3.
Yeah. Agreed.
Okay. Here's a question about the hardship test for variances. Is it correct that the test described in 1A, 2E is broken into two parts? If the A test is satisfied, does the ZBA not need to consider Part B? Can you provide an example describing when to apply the second part of the hardship test?
Sure. You're absolutely right. There are two prongs. If you look at the language, however, and this is part of the Supreme Court's jibe at the legislature in the Harborside case, they are very, very close together. The legislature intended B to be the old Governor's Island case, which was you couldn't use it at all for reasonable use without a variance. That's not what B says. But I agree with you. You don't get to B if you have met A, because the statute says you only get B if you didn't meet A. An example for B would be overlapping setbacks. I have one right now about to go into a Lakes area town where the lot is a postage stamp. The setbacks literally overlap so that when the plan first was given to me by the applicant that he'd gotten from his surveyor, I was going, okay, it looks like we're encroaching on the side setbacks on each side. And then I realized, wait a second, your width is only 55 feet. The setback line on the left side of the page was the setback from the right side property line. The setback on the right side of the page was from the left property line. They overlapped. There was no legitimate building envelope. That's a B in my eyes.
Yeah, and I completely agree. It's rare, but that's the kind of time you see it. And it is an alternative. It's like basically, if you can't get through the first part, this is kind of the fail-safe for someone who really has a problem lot.
To prevent the regulatory taking.
Exactly. Having literally no use of your property.
Okay, great. After that, there were two questions, which I believe the attendee was basically repeating from the first session. So you answered those. One was about the term appeal, and then regarding the receipt of the application. So I think those you answered just a few minutes ago. So I'm going to move on to the next one. If it is too select, yep.
Yeah, I think we did that one as well.
The one about the two selectmen?
Show up at the meeting?
Yeah, if they're showing up, then it is a select board meeting too and needs to be noticed as such. So not a question, but do you wish to respond to that?
I think we addressed that. It may not be a selectmen's meeting, but to avoid the appearance of impropriety, it's better to post it that, hey, on Tuesday night, two of the selectmen may attend the ZBA hearing on the Jones matter. It's not a meeting of the select board, it's a meeting of the ZBA.
Okay.
Something like that, I think.
Okay. And this is a follow-up, I think, to the appeal discussion. Would the view of this be different if a building permit application was denied because it could not be approved without a variance, special exception, et cetera? Is that an appeal of the building permit denial?
Well, I guess, as Chris would say, it depends. If I apply for building permit and I'm denied, saying it doesn't meet a particular requirement and I need a variance, let's just say variance, and I appeal that reasoning and say I don't need a variance because I don't violate the ordinance, I meet the ordinance, then I'm appealing the interpretation of the ordinance. That's an administrative appeal. If you deny my building permit for whatever reason and I need that variance and I go apply for the variance, then to me you're acquiescing that, yeah, I need to go get the variance, I'll apply for the variance. I'm not challenging the decision, I'm just following through with what I've been instructed to do in order to get my permit.
I will disagree slightly. I think there's no acquiescence because of the Bartlett v. Manchester case, that you can come in and say, I'm applying for the variance, but first I want you to determine whether or not I actually need it.
Yeah, sure.
And I've done that several times on the private side. I've seen it done several times on the ZBA side. And I think that's a legitimate question. Look, I'm not going to file a second application for appeal of administrative decision because I know if I'm not correct, I have to file the variance. I can file the variance, and my first paragraph is, do I need to be here, guys? And they make the determination, yes or no.
Yep, no, and I'm sorry, maybe I misspoke. I agree, you can, that's fine. I was saying in the context of someone who just agrees that, I'm just going to go apply for the variance. That's not an appeal, that's still an application. But to your point, if someone is questioning whether they need it, I think they could wrap that into the same application. I had that too a while back, where someone wrapped it into the variance itself. Was the first issue was, we don't think we need it, so let's get through that first, and then if we do, here's our application. Here's your request for the variance.
I give you the off ramp real quick, ZBA, if you want it.
Yeah. And I don't think you need to force them into the hoops of doing a separate administrative appeal and then a separate, I'm not going to do that's not working with citizens, in my opinion.
Right.
Okay. Next question. When finding that an application is incomplete at the hearing, does the ZBA then have to make a decision to deny the application as incomplete without prejudice?
I'm not sure I've ever addressed it that way. I would think that being incomplete means that you haven't gotten to the start location for the denial that would then trigger Fisher v. Dover. So you're before that, and therefore I think the vote that it's incomplete for X, Y, and Z is all that's needed. Does that answer the applicant's the question? Does ZBA then have to make a decision to deny the application as incomplete without prejudice? I don't think you need the without prejudice, put it that way. I think it's automatic because there's no prejudice can attach to the incomplete application. You haven't gotten to the denial that triggers Fisher v. Dover.
Right, yeah, I think you're not ruling on the merits of the application yet.
Right.
You're just saying we can't do anything with this. We don't have, something's not filled out or whatever.
Yeah, there's no there yet.
Yeah, right, exactly.
Okay. I see that the next question, I think, is a repeat of one that he posted earlier and that you have now answered about conditions precedent. So I think we can pass that one over. So therefore, therefore the next one is, what is the process to compel someone like the building inspector to appear to testify at a public hearing?
There is a statute. I'm thinking of it, trying to remember it. But the ZBA does have the power to compel witnesses.
Yeah, I can't remember the number off the top of my head, Chris. Haven't had to go to that one in a long time.
I haven't had to go with that one in a very long time. 673-15.
Yeah, I'm on there right now.
Chairperson of the zoning board, chairperson of the Code Board of Appeals, chairperson in absence the acting, may administer oaths whenever the board exercises regulatory or quasi-judicial. It may, at sole discretion, compel the attendance of witnesses. All expenses incurred, compelled, or paid by the party or parties requesting the witness be compelled. So it's in essence a interior subpoena. Now I can say I strongly recommend when an appeal of administrative decision is brought to one of my towns that you notify the applicable officer, whether it's the planning board chair or the code enforcement officer or the selectman, to say, hey, we got this. We're going to need the whole file because that's one of the requirements of the rule.
Right.
And please show up. We're going to have the hearing on X. I haven't had anybody say, I know I'm not coming. I have had a couple saying, no, I don't want to come. But it usually is they're there and do you have anything to add? And the recalcitrant ones say, no.
Chris, what do you think if you did have a difficult official who said, no, I'm not showing up. I'm not participating, even though they've been compelled to show up. What authority do you think the board has beyond that to force that to court?
Yeah, or it's one of those things. We don't have injunctive relief. You know, I don't know of a cause of action that the board would have, but I can say that would weigh heavily if I was a board member on reversing whatever that decision was.
That's what I was thinking. It's more your choice not to appear, essentially will be held against you
Right.
in the decision. Yeah, that's kind of where I land on it.
Because you're not here to defend a decision. We can see the written decision. We're hearing from the applicant, this is wrong. We've required you to be here and you're not here. Gee,
Yep.
Whose side am I going to come in on?
Yeah. Yep.
Okay. Next one. Recognizing that a special exception has to meet the conditions codified in the local ordinance, I wish to confirm that a ZBA can place conditions precedent or conditions subsequent on granting the special exception, similar to placing conditions on a variance.
Yeah, I mean, sorry, Chris, I don't know if you're going to say anything. ZBA can place conditions on variances and special exceptions as far as I'm concerned. Not sure what, special exceptions are a little different in the way they're, in terms of their criteria. So I'm not sure you'd have as much in the way of conditions attached to something like that than you would a variance, but
Right.
I don't see anything stopping them from attaching some conditions if they were necessary.
Yeah,
Chris?
that's where I was going, Matt. They are different, and you have this checklist, and they're supposed to get it if, by the case law, they meet the checklist. So I would want, as a town attorney, to know, preferably in advance, why you think a set of conditions or an additional condition are needed. If it's something other than getting the shoreline permit or getting the septic permit or getting the DOT road cut permit for the driveway, those are automatic and those are conditions. And yeah, that's great. Keep in mind that sometimes your decision is the first milepost in a long journey that takes the applicant to the planning board. Sometimes your condition can be as simple as, and you've got to get planning board approval for this. So everybody knows we ain't the end result. Now you get to go on to eat more heartache and go through more hoops.
That's a great point too, because I know sometimes you'll see ZBAs who, in some ways want to get a little bit over their skis and start to add conditions about operating hours and things like that, where that's really going to be more the planning board through site plan or whatnot than at the ZBA level.
Right.
So, to the extent those are conditions, leave that to the planning board.
Right. And I would emphasize that. If it's a project that's going to go to planning board, let them deal with the minutia. You are here for location and use issues. And if it's a topic that will be discussed there, I think you have every right to say, and we want the planning board to focus, get evidence on X, Y, and Z. If that's a concern, that puts it in the planning board's bailiwick. You've raised the flag, but it's their bailiwick, not yours.
Yep.
Okay, very good. Thank you. Okay, next one. They say, please confirm, in case of a ZBA denial of a request for rehearing, it is only necessary for the ZBA to formally issue a denial, but not the reasons for the denial. And by what venue should such denial be issued? A letter to the appellant for rehearing?
Great question. I think the statutory amendment muddied the water because I believe it says any decision.
Yeah.
676.3, the local land use board shall issue a final written decision which either approves or disapproves. Well,
if you read Roman 2.
Whenever land use supposed to approve or disapprove, the minutes of the meeting to All conditions of the approval shall be placed on file.
Written decision, reasons there, condition, contain the reasons.
Containing the reasons thereof and all conditions of approval.
So, yeah.
Yeah, so I would view it as it's better to include, don't do the motion for rehearing is denied. I think that's the equivalent of your application is denied, and the Housing Appeals Board and likely the court will punt those back. However, if you say the motion for rehearing is denied because no new evidence was submitted, the arguments were appropriately addressed at the underlying hearing, and the board believes that its prior decision was lawful and reasonable. Those are findings. Those are statements. And I think that would suffice.
Yeah, I totally agree. That's a safe way of just saying they didn't meet the standard of review there. And it prevents what we warned about in the first session with the the Effingham problem, where you deny a motion for rehearing and you happen to add one or more new reasons,
Right.
Even if you don't mean to. Then you've opened up a whole nother can of worms. So right. I agree with Chris. I think that's a safe way to do it.
But it is, I think, it needs something in writing, and I don't think there is a form required, but it makes sense to do it like your notice of decision, the same format. Has the style of the case and the case number if you've added one, and goes through on the meeting date. We consider the motion for rehearing filed by Joe Jones. The vote was 5-0 denying it because bing, bing, bing.
Yep.
Okay. All right. Next question. When someone buys a piece of property knowing the limitations on said property, are they buying into the hardship? And is that a valid reason to deny?
The self-created hardship problem. I chuckle because I don't know how many times I've tried to argue that, and I've never had success with the court or the Housing Board of Appeals.
Right.
I think the case law, such that there's not a lot of cases on this, but
yeah, Harrington is the last one I can recall.
Yeah, I mean, look, it says it right there. It's not dispositive in and of itself, but it's certainly something to take into consideration. And I'll always keep arguing it. If someone buys something, fully realizing they're buying a problem, then again, I understand the counter argument that, well, if that was the case, then when could we ever get relief? Because more often than not, we're buying something that, poses a problem until we have to get the relief. But so, yeah, I mean, it's out there. It's New Hampshire doctrine. I still argue it when I think it's relevant, but I just have yet to have any real success with it before the various tribunals. Chris, what about you?
I agree. I've got the same experience. The Harrington case clearly says it's a non-dispositive factor. And it is one of those things. The common law concept of property rights is a bundle of sticks. When you buy property, you buy a bundle of sticks that have various attributes. One of which may be the ability to build on it, the ability to rent it out, to improve it, or whatever. I think arguably one of those sticks is to apply for any legitimate regulatory relief. You have to meet 5 criteria. Those 5 criteria do not say, and it didn't exist when you purchased the property. It could factor in is, okay, is this use reasonable, or substantial justice, the balancing test that we talked about earlier, Annie. So it's really one where it can be, but I don't think it's the deciding factor. It can be considered, but it's not the deciding factor. I hope that helps.
Yeah, before we leave this, Chris, you made a great point, I think, before we leave this, and that is the idea of that really standing on its own, it doesn't seem to have a lot of weight with the courts. But I think when you argue it in the context of something like a substantial justice, which we know is this balance of private versus public interest kind of thing, I think there is a great way to kind of add it in, which we do anyway, I think, if we're putting these things together. But that's really, I think, where it's going to have more meaning than kind of just on its own as a separate section, as I pound away on the case and keep saying it's self-created hardship, it's self-created hardship. It just seems to get, ignored if I do it that way. So,
yeah.
Okay. This next question, I believe was actually discussed at the previous session with Steve Whitley. So we'll ask it here too. Are cumulative effects factored into ZBA decisions? For example, one of the criteria for a special exception might be that there is no excessive demand on municipal services. How does the ZBA consider that while an individual project may not create an excessive demand, the cumulative effects of multiple projects that are in the pipeline might? Is it assumed the planning board addresses this? And then Bacon versus Town of Enfield, does this inform the question?
Yeah,
I spoke at some length during my session on how Bacon v. Enfield's cumulative impact statement of a concurring opinion is, I think, now fairly dead. We definitely have it rejected in the Dietz v. Tufton Borough equitable waiver case. We have it questioned in earlier cases in variance land. Starting with Perot, even though the court recognizes the applicant didn't raise the issue, and therefore we won't decide it on this case. But I think it's Harborside that said that concurring opinion is not has no precedential value because it's a concurring opinion. Cumulative impact, for example, on no excessive demand of municipal services, I think has to be this project. If this project is going to require in and of itself a new fire station because they're putting in 127 lots, or it's going to need a new sewer upgrade because of those lots or whatever, then that criteria may not be met for this project. If this project is putting in 2 lots, 2 lots is not going to have that much of an excessive demand on municipal services. Putting in the convenience store may not have that much demand on municipal services. Putting in a super Walmart, maybe it does, I don't know. But it's I think a question of size of that project.
Yeah, I agree with Chris. I think the way I've seen the courts and the housing board looking at this, it's definitely case specific, at least these days. And I've tried to argue that cumulative impact issue, and it really, again, doesn't get much traction, understandably. I mean, I know it's sort of a shot in the dark because we are working from a concurring opinion to begin with. But it really is that case, that matter before you, that is the issue and the impact. Otherwise, we are, as a board, speculating, and there's conjecture what's to come and what the future holds, and denying this now because of a danger of horrible things to happen later, which may or may not happen. Yeah. So, I agree, Chris. I think stick to your guns and stick to the application before you, and don't get hung up on the future potential impacts of similar projects or other unknowns that could come down the pike.
And the same thing is true. I've heard it, both sides of the aisle. Well, we can't grant this variance because everybody's going to want one. And it's like, folks, a variance is site specific. It is based on the special conditions of this property, the relief sought for this project, the provisions of the specific ordinance provision that you are seeking relief from. The court cases also tell us they don't have any precedential value because each piece of property is different. Just because you grant one for member A doesn't mean you have to grant one for member B if there is sufficient differences between the two properties. Corollary to that, or the odd point of that, going back to Garrison v. Henniker, is if there's no distinction between the two properties, then there's no special conditions of the properties that distinguish it from others in the neighborhood, and therefore they don't meet the necessary hardship standard. Remember that's the downfall of the explosives plan application in Garrison. The court came in saying there's no substantial difference with these 1,600 acres than any other residential acreage in Henniker. I, for one, would have thought having 1,600 acres of undeveloped land anywhere in Henniker would have been a substantial, a special condition. But court didn't see it that way. So the issue is there a special condition of the property? May be the way to address your concern. Tom.
Okay. I have another question. This one says, I used to ask the ZBA if a variance application was complete. Since the recent changes in statute, I've been told the question should be, is there sufficient information for the ZBA to make a decision? Which should I be doing?
I guess I'm going to kind of say kind of both in a way. I mean, you want to make sure obviously the application is complete, and that meaning that the formalistic items are done, everything's completed, it's signed, it's dated, all those things, fees paid, all that kind of stuff. But that's more administrative. But then obviously the information that's before you, you may not have enough information right away in terms of making a decision. That's what the hearing's for. So you're going to be getting evidence, testimony from whomever to support the various statements that are made in the application in support of the criteria, which hopefully there's something. And, we always have to keep in mind that you have a lot of different people coming before you, whether they're self-represented, they may have a sophisticated lawyer like Chris, or they have an engineer or whomever. So it's a wide variety of information you're going to get. Some's going to be really detailed and great at the forefront. Some's going to be real scarce. And obviously, as we talked about assisting citizens, you can't, make their case for them. But at the same time, they have to understand what they need to do and what they need to their burden. We talked about that before too, what the burden is. So I've always said, approach these, especially with ZBAs, I approach these so we're not too critically and give the applicant a chance to kind of fill in the gaps during the course of the hearing. So that's a long way of saying, I don't, put too much. I mean, as long as the application is completed and there's enough there to at least begin the process and to have questions, etc. I think it's fine to proceed in that fashion. I wouldn't get overly critical with an application in the sense of saying it's not good enough or we're not going to continue with this. Whereas I might with the planning board, since they have detailed checklists and things like that and waiver requirements that you can seek and all that. So I just see a bit of difference there, but that's me.
My first reaction was it's really a distinction without a difference. The two things technically are the same. I know what you're referring to. You're going through to 674.33.8, the new provision that was added that changed the timeline and clearly gives the authority of a denial without prejudice. Does use that phrase, if the zoning board determines that it lacks sufficient information to make a final decision on the application and the applicant does not consent to the extension, then the board can do the deny without prejudice. I think the importance is to remember that phrase is used for something that's happening at the end of the hearing process.
Exactly.
Determining whether the application is complete is happening at the beginning of the hearing process. But I think they're really the same, largely the same. Do you have enough information in the application originally to take it up and proceed? You may find as you're going through the hearing, as many times you do, you need more stuff. An abutter has raised a valid question. When I'm on the applicant side of life and somebody raises a good question, I go to the old rule I was taught as a kid. When you're caught, be gracious. Say, yes, I want to get that new information to you. Rather than I saw somebody the other night say, no, I'm not going to give you that. And it's like, really? And oddly enough, they got a denial without prejudice, but show me the stuff. So think of the timing of when those questions are asked.
Okay. We have, I think, time for one more question.
Sure.
This is a long one, so I think you have it there on your comments.
Do you have another question?
Well, Chris can see it. I can't see it, but go ahead.
Herb, you've got some great ones throughout the day.
Oh, that's what you're asking, huh?
Do you want me to read it
out?
out?
Yeah, go ahead. Read it all.
Okay.
Go ahead.
It'll give me time to think about what the answer should be.
Excellent. Seeking understanding of preemption versus avoidance of conflict with regard to state statutes and implications of the latter. Preempt means the state has exclusive regulation with no allowed regulations by local. Think state regulation of docks on public waterways. Is this the general rule? Unless the statute carves out preemption, then the presumption is that local regulations merely need to avoid conflict with regard to the statute. Avoidance of conflict means avoidance of local regulations that would frustrate the purpose of the statute. Does avoidance of conflict depend on whether the statute is permissive or restrictive, in which case local regulation could be either less or more stringent, respectively? One more paragraph. For example, it appears the ADU state statute allows for both less restrictive regulations and more restrictive regulations. To wit, statute allows local ordinance to establish a maximum size for an accessory dwelling unit, provided that the size may not be restricted to less than 750 square feet. That's less restrictive. But for that same statute, local ordinance apparently can restrict ADUs to not include short-term rentals for transient guests, e.g. Airbnbs, used as a hotel or motel, although the state statute does not make that limitation. Got all that?
Oh, darn, we're out of time. Oh boy, that's a great law school question, Herb. The thing that springs immediately to mind is watch House Bill 1291 on ADUs. That's coming back to the Senate Finance Committee on Tuesday, I believe. Because the world of ADUs may change yet again if that thing passes. Generally, I believe you are correct. Preemption requires the statute to give the imprimatur of exclusivity. The state is regulating X. I think the clearest case was the Conway, what was it, Mountain? Basically, it was cigarette smoking in a restaurant situation, and it was viewed as the town regulation is preempted by the state regulation. I believe is the way that one came out. I'm not sure that there is a zoning ordinance provision. Well, I guess there could be that would somehow violate a state statute and thereby be preempted. But I'm not sure how else to answer the question. There is a difference between preemption and conflict avoidance. You're absolutely right. But if you're facing a preemption question, call your lawyer without a doubt, because it's not one of those things to go tread in lightly.
Yeah, and preemption is a funny thing because, generally we use the phrase, completely occupying the field is sort of what the legislature does when it takes control of a particular topic. But at the same time, we know there's carve-outs that they've created for local control. And Chris, you're familiar with this with junkyards.
Yeah.
They clearly say the zoning ordinance can be more restrictive than the statute. Same with excavation regulations. There's minimum standards that control no matter what, but otherwise you can have your own local regulations, and they can, if there's a conflict, the more restrictive control, if my memory serves me correctly.
Correct. But you have to
there's-
have the local regulations. If you don't,
Exactly.
the state statute controls.
Exactly. So the opening's there, but otherwise state statute controls. So it's really a murky situation, and with the ADUs especially, it gets even murkier. And I'll have to look at 1291. I'm not sure what the standard was. That the one, Chris, where they're going to go for 2 ADUs now?
Yeah, at
one?
least, and one, depends upon very little on size. 2 if 2 are allowed if the lot is over half an acre. And it's not clean. My concern is it's not cleanly tied to being on a municipal sewer system. It's I think not required to be on a municipal sewer system. So you could have a whole lot of changes going on in a whole lot of areas where the committee of the 400 under the Golden Dome may not necessarily realize what they're doing, but you never know. And if I've just offended anybody who happens to be a member of the legislature, my apologies.
And on that note,
that's right. Well, I would say
his name is spelled B.
We have come to the end of our time for this session and also for the conference today. So I just want to once again thank all of our presenters for the time you've put in today and your willingness to answer lots of these questions. Just remember that the slides and the recordings will be available next week online. And just want to encourage you to fill out our feedback survey so we can do a better conference next year. And with that, I will thank you all for being here.
Thank you much, folks. Appreciate the questions.
Thank you so much.
And be safe out there. Enjoy the rest of the day.
All right. Very good. Have a good day, everybody.
Thank you, Ken. Appreciate you being moderator.
Yep.
Matt, always a pleasure.
Yep. Yeah, absolutely. Wonderful. Love the session.